This guide answers one practical question. What should a seasonal worker in Colorado check first in 2026 when the issue is overtime pay or job injury? We will stay with official sources only. As stated on the Colorado Department of Labor and Employment website, cdle.colorado.gov, and in the official Colorado wage rules, the answer depends on the exact category of work, not just the word seasonal. So the plan is simple. First, the general overtime rule under the Colorado Overtime and Minimum Pay Standards Order, the COPS order. Second, the narrow seasonal exceptions. Third, the special agricultural overtime framework. Fourth, workers' compensation coverage. Then injury reporting, medical care, and how to file a claim. Scan the code on screen for the Colorado Labor Rules page. According to the Colorado Overtime and Minimum Pay Standards Order called the COPS order, in the division's Info Number 1 guidance, most non-exempt employees must receive time and one-half after 40 hours in a work week, after 12 hours in a workday, or after 12 consecutive hours, whichever gives the higher pay. The official website also says employers cannot average hours across weeks, and they cannot substitute comp time for overtime wages. That matters for seasonal businesses because long resort weeks, fair weeks, or event weeks can still trigger overtime if no exemption applies. You can find the official summary on the Colorado Department of Labor and Employment website, cdle.colorado.gov. Seasonal work is not a blanket overtime exemption in Colorado. The COMPS order covers private sector work unless a listed exemption applies. One specific seasonal exemption in COPS order number 40 covers certain field staff of seasonal camps or seasonal outdoor education programs, but only when the rule's exact conditions are met. The staff must primarily supervise or educate, must reside on-site or in the field, receive lodging and meals without wage deductions, and meet the pay conditions written into the rule. So when a worker hears that a job is seasonal and overtime does not apply, the next question should be, which exact COPS exemption, if any? The full rule text is available through the Colorado Department of Labor and Employment and the Colorado Secretary of State Rules site. Colorado agriculture has its own overtime structure, as explained in COPS order number 40 and in Info number 12 from the Division of Labor Standards and Statistics. Agricultural employees are treated differently from the general 40-hour and 12-hour overtime rule. In 2026, the main weekly threshold is usually overtime after 48 hours in the work week. A highly seasonal agricultural employer can use a 56-hour threshold during up to 22 peak weeks, but only with the required disclosures and only if the rule's definition is met. The same Colorado guidance also adds long day protections, including a longer paid third rest break after more than 12 hours and extra pay after more than 15 hours. For the official agriculture guidance, scan the code for cdll.colorado.gov. Workers' compensation is a separate question from overtime, and seasonal status does not erase it. The Colorado Division of Workers' Compensation says that if an employer has one or more employees working in Colorado, the employer must maintain workers' compensation insurance. The official page says this applies regardless of whether employees are part-time, full-time, or family members. It also says a person hired to perform services for pay is presumed to be an employee, and the employer cannot deduct any part of the premium from wages. On the official insurance coverage page at cdlel.colorado.gov, the division warns that being uninsured can lead to daily fines and added penalties if a worker gets hurt. If a seasonal worker is hurt on the job, speed matters. On the official injured worker pages of the Colorado Division of Workers' Compensation, cdll.colorado.gov, workers are told to notify the employer in writing within 10 working days of the injury. In an emergency, the worker should go to the nearest emergency department. In non-emergency situations, the employer must provide a designated provider list, and the worker usually chooses from that list. The division also says that if the employer does not provide the written list within 7 business days after notice of the injury, the worker may choose their own doctor. These steps are procedural, but they can control medical choice and protect benefits. Colorado Workers' Compensation provides medical and lost wage benefits for on-the-job injuries. The official injured workers page says a worker should file the WC-15 workers' claim for compensation form with the division within 2 years of the injury. The same page says workers should still file even if the employer had no insurance, because they may qualify through the Colorado Uninsured Employer Fund. So the practical sequence is this: report the injury in writing, get medical care through the proper provider rules, and file the WC-15 if you need to protect the claim directly with the division. The official forms and instructions are on the Colorado Division of Workers' Compensation pages at cdlel.colorado.gov. Here is the fast checklist for 2026. First, identify the work category. General Colorado employment, a narrow seasonal camp exemption, or agricultural employment. Second, compare the hours to the correct overtime rule. Third, if there is an injury, preserve the record, written notice, pay stubs, schedules, the provider list, and claim forms. And fourth, use the official sources directly, the Colorado Labor Rules pages and the Division of Workers' Compensation at cdlel.colorado.gov. This presentation is educational only, not legal advice, but the official sites on screen are the right place to start when a seasonal Colorado job raises overtime or workers' comp questions.